Again, welcome back, Attorney Steve Vondran, and welcome to another exciting video. Today we are talking California, right of publicity. Many states have a right of publicity law. California and New York are two of the big ones. And the Hilton, Paris Hilton versus Hallmark cards case. Let's get into it. Without further ado, let's head to the Attorney Steve litigation whiteboard. All right, we're back here. All right, so this was a fun case, okay? Hilton, everybody knows Paris Hilton. That's hot. So she was in a reality TV show where she basically played a waitress. And, you know, there was some humor about sending the plate back and forth. Oh, that's hot, you know. So Hallmark Cards thought they would do a card, a little play off that, if you will, a little play off that, and make their own card. And it's used her image with a cartoon character body. And so whenever you're using somebody else's name, image, or likeness, as we show right here, nil, name, image, or likeness, you need to be careful because under California law, they can sue you for damages and attorney fees for a violation of what's called their right of publicity that every person has in California anyway. Check your local states, and you may not have it in your state, but in California, everybody has a right of publicity, okay? So you can't just go taking somebody's picture, putting it on a cereal box, putting it in a Hallmark card, and just go, hey, we're just having fun. She's a celebrity. Let's try to use her to sell cards, see how many cards we can sell. Okay, so this can lead you into legal hot water, okay? So you don't necessarily want to do that without consulting with an attorney. So Paris Hilton, she saw the card, and we'll take a second here and take a quick look at the card. So she decided she was going to retain legal counsel. She filed a lawsuit against Hallmark. Now, Hallmark came back and said, well, wait a second. This is kind of a transformative use. It's kind of a First Amendment thing where it's a parody. We're transforming her into something funny where we're saying that's hot in relation to food and a cafe. We're transforming it into something totally different. It's a First Amendment thing, okay? Courts didn't really buy it, okay? They tried to file what's called an anti-SLAPP motion. If you haven't watched my video on anti-SLAPP, I'm going to put it down in the description area. Make sure you check that. Anti-SLAPP is a good thing if you actually truly have a First Amendment right at issue, like you're just stating the facts and somebody wants to sue you for defamation, or you're just doing something fun and parody and somebody wants to sue you for a right of publicity, on and on and on. So there is such a thing as the First Amendment in the United States. So Hallmark said, well, wait, this is protected. This is a First Amendment. We're transforming this into something new, fun, transformative, and that's a defense to the right of publicity in California. So this is what happened. So the court had to hear this anti-SLAPP, and the anti-SLAPP basically is a very important tool because it does something really quick. It puts them on notice that you think they're filing this lawsuit as a strategic lawsuit against public participation, SLAPP, strategic lawsuit against public participation, and they need to be prepared to prove the merits of their case right up front. And that's the beauty of an anti-SLAPP. But the pitfall with an anti-SLAPP is if you file the anti-SLAPP and you lose, you know, you're putting yourself in a deeper hole in the litigation, and the non-filing party, the other party can seek their attorney fees, okay? So it sets a really interesting opening scenario for litigation when an anti-SLAPP is filed, challenging First Amendment rights, things like that. But in this case, ultimately, the court denied their motion, saying that this was a public interest, that it was newsworthy. Newsworthiness is a defense to California right of publicity violations. But the court said, no, this isn't newsworthy. It's a commercial card. You're making money. You're not telling the news, you know, nothing like that. So ultimately the case settled, but this was a really interesting case, how it progressed with the anti-SLAPP motion, and basically ultimately with the court saying, yeah, could be transformative. We'll send it down to the lower courts. We'll take a look at it. But the court expressed some reservations in finding that this was going to be transformative merely by turning it into kind of a cutesy Hallmark card. So ultimately, as I understand it, the case was settled, and that was the end of the case. So right of publicity, First Amendment, transformative use, fair use. AttorneySteve.com, you know where to find us on the web at AttorneySteve.com, the first name in legal services. So general legal information only, not legal advice, but you can see some of the dynamics at play when you have a celebrity or even a non-celebrity, as I mentioned, a right of publicity claim, nil, name, image, and likeness. She also, coincidentally, she has a trademark on That's Hot. And I don't know what's it in line with. Maybe it's her clothing or perfume or something. It has to be tied to goods or services. And she tried to bring a trademark claim, but that was dismissed. Okay. So there you have it. This is kind of the anatomy of how a right of publicity case can go and a potential defense. 2 potential defenses if you have something newsworthy, which is a whole nother analysis. But I hope this has been helpful. General legal information only. Attorney Steve, right of publicity.